Hello students, welcome back to Varanda Race Institute. Here at Varanda Race Institute, we provide coaching for those aspirants who are appearing for competitive exams such as PC, PSI, FDA, SDA, VAO, PDO and Group C examinations and banking examinations as well. And students, also KPSC students especially, you have to be, see, for KPSC students already KPSC batch is in its orientation phase, which is happening here at Varanda Race Institute offline batches. So KPSC students, those who want to dedicate their 5 months, working hard for the KPSC exam, you can join us. Already offline batch has started. It's still in the nascent stage, still the orientation is going on. Link will be in the description. If you could follow the link and join us, so you will be getting the benefit of this coaching for the 5 months. And also there is scholarship offer of up to 15,000 and also a discount on the fees also. So don't miss it, students, KPSC students especially. Hurry up, make your decisions, take wise decision. We will make it right, and join us soon at Varanda Race Institute. So students, welcome back to today's topic. Today we are going to start with fundamental rights. ಮೂಲಭೂತ ಹಕ್ಕುಗಳು, and the articles which we will be dealing with today is article 12 to 14. Very important article. When you are starting with fundamental rights, these articles are very important. The beginning articles, article 12, 13, 14. Jyoti ma'am, hi ma'am. Hallu KSP, hi sir. Cricket history, hi sir. ಬಸವನ ಬಾಗೇವಾಡಿ, ಕ್ಲಾಸ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ರಿ. ಮಾಡಿದೀವಲ್ಲ ಸರ್? Okay students, having said that, today we are going to start with fundamental rights, article 12 to article 14, ಮೂಲಭೂತ ಹಕ್ಕುಗಳು. ಅದ್ರ ಬಗ್ಗೆ ತಿಳ್ಕೊಂತಿದ್ದೀವಿ ಇವತ್ತಿನ ಕ್ಲಾಸಲ್ಲಿ. ಮತ್ತೆ ಗೊತ್ತಿರುತ್ತಲ್ಲ ಸ್ಟೂಡೆಂಟ್ಸ್, KPSC ಸ್ಟೂಡೆಂಟ್ಸ್ ಯಾರಿದ್ದೀರಾ, 5 months ಡ್ಯೂರೇಷನ್ ಕೋರ್ಸ್ ಇದೆ. ಮತ್ತು ಆಲ್ಸೋ ಇನ್ನಿತರ ಎಕ್ಸಾಮ್ಗಳೇನಿದೆ, PC, PSI, ಎಕ್ಸಸೈಸ್ SI, ಕಾನ್ಸ್ಟೇಬಲ್, FDA, SDA, ಗ್ರೂಪ್ C, VAO, PDO, CTI ಎಕ್ಸಾಮ್ಸ್ ಹಾಗೂ ಇನ್ನೂ ಹಲವು ಎಕ್ಸಾಮ್ಸ್, ಕಾಂಪಿಟೇಟಿವ್ ಎಕ್ಸಾಮ್ಸ್ಗಳಿಗೆ ಇಲ್ಲಿ ನಾವು ಕೋಚಿಂಗನ್ನು ಕೊಡ್ತಿದ್ದೀವಿ. ಸೊ ಲಿಂಕನ್ನು ಫಾಲೋ ಮಾಡಿ, ಲಿಂಕ್ ಡಿಸ್ಕ್ರಿಪ್ಷನಲ್ಲಿ ಲಿಂಕ್ ಇರುತ್ತೆ. ಆ್ಯಂಡ್ ಆಲ್ಸೋ ಸ್ಟೂಡೆಂಟ್ಸ್, ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್, ದೇರ್ ಆರ್ thousands of vacancy released by the government, but you will be confused for sure which job is better for me, or why should I choose this particular job. So to get answer to that, we are conducting live webinar by our dedicated mentor Ashwini ma'am. That is on Saturday 14th June 2025, 7 PM Zoom call. Don't miss. Time note ಮಾಡ್ಕೊಳ್ಳಿ, 7 PM Zoom call, Saturday June 14, Saturday. Live webinar will be conducted based on which government job is suitable to your personality, or what you are looking forward for from the government job. So it will give you better vision and clear vision to which exam you need to go with. So don't miss it, students. Now we are starting our today's topic. The registration link for both KPSC batch and the webinar link will be in the description. Please follow it. You have to register before webinar so that you will be given link for access the webinar. Unlucky, yes, namaskara sir. So let's start with today's topic, students. Fundamental rights. What do you mean by fundamental rights? ಕನ್ನಡದಲ್ಲಿ ಏನಂತಾರೆ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ಗೆ? ಮೂಲಭೂತ ಹಕ್ಕುಗಳು. ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್, ವಿಚ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ಇನ್ ದ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್, ಭಾರತ ಸಂವಿಧಾನದಲ್ಲಿ ಮೂಲಭೂತ ಹಕ್ಕುಗಳೇನಿದೆ ಪ್ರಜೆಗಳಿಗೆ ತುಂಬಾ ಇಂಪಾರ್ಟೆಂಟ್. ಅದು ಮೂಲಭೂತ ಹಕ್ಕುಗಳಂತ ಹೇಳ್ತಾರೆ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ಗೆ ಕನ್ನಡದಲ್ಲಿ. ಆ್ಯಂಡ್ ಬಿಫೋರ್ ಗೋಯಿಂಗ್ ಅಹೆಡ್ ವಿತ್ ದ ಆರ್ಟಿಕಲ್ಸ್, ಲೆಟ್ಸ್ ಸಿ ವಾಟ್ ಆರ್ ದ ಫೀಚರ್ಸ್ ಆಫ್ ದ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್. ಇಟ್ಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ವೈ fundamental rights were added in the constitution. What is the presence? Why is it present in the constitution? So first, fundamental right, they are not absolute but qualified. In my previous sessions, this is our 8th session. In our previous sessions, I have repeated multiple times that fundamental rights are not absolute. Not absolute ಅಂದ್ರೆ ಏನು? ನಾನು ತುಂಬ ಸಲ ಹೇಳಿದ್ದೀನಿ ಹಿಂದಿನ ಕ್ಲಾಸ್ಗಳಲ್ಲಿ, ಸಂವಿಧಾನನೇ ನಿಮಗೆ ಮೂಲಭೂತ ಹಕ್ಕುಗಳನ್ನು ಕೊಡುತ್ತೆ, ಮತ್ತು ಅಗತ್ಯ ಬಿದ್ದಾಗ ಸಂವಿಧಾನನೇ ನಿಮ್ಮ ಮೂಲಭೂತ ಹಕ್ಕುಗಳನ್ನು ಕಸ್ಕೊಳ್ಳುತ್ತೆ ವಾಪಸ್ಸು. ಅದಕ್ಕೆ ಕೊಡೋಕ್ಕೂ ಗೊತ್ತು, ವಾಪಸ್ ತೊಗೊಳೋದಕ್ಕೂ ಗೊತ್ತು. ಹಾಗೆ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ಆರ್ ನಾಟ್ ಆಬ್ಸಲ್ಯೂಟ್ ಬಟ್ ಕ್ವಾಲಿಫೈಡ್, ಮೀನಿಂಗ್ ಸ್ಟೇಟ್ ಕ್ಯಾನ್ ಇಂಪೋಸ್ ರೀಸನಬಲ್ ರಿಸ್ಟ್ರಿಕ್ಷನ್ಸ್. ನಾನು ಆಗಲೇ ಹೇಳಿದ್ದೆ, ಸಂವಿಧಾನ ನಿಮಗೆ ಮೂಲಭೂತ ಹಕ್ಕುಗಳನ್ನು ಕೊಡುತ್ತೆ, ಹಾಗೂ ಅದನ್ನು ಆ ಮೂಲಭೂತ ಹಕ್ಕುಗಳನ್ನು ಯಾರ ಕೈಲೂ ವಯೋಲೇಟ್ ಮಾಡೋದಕ್ಕಾಗಲ್ಲ. ಆದರೆ ಸಮಯ ಬಂದಾಗ ಸರ್ಕಾರ ಏನಿದೆ, ಸರ್ಕಾರ ನಿಮ್ಮ ಮೂಲಭೂತ ಹಕ್ಕುಗಳನ್ನು ಕಸ್ಕೊಳ್ಬೋದು. ಎಕ್ಸಾಂಪಲ್, ಡ್ಯೂರಿಂಗ್ ಟೈಮ್ ಆಫ್ ಎಮರ್ಜೆನ್ಸಿ, the fundamental rights, on fundamental rights state can impose reasonable restrictions. Okay, fundamental rights are not absolute but qualified, please keep it in mind. Second point, they are defended and guaranteed by Supreme Court. Very important statement, very important point. In any competitive exam there will be a question, who is the ultimate guarantor of fundamental rights? ಮೂಲಭೂತ ಹಕ್ಕುಗಳೇನಿದೆ ಭಾರತ ಸಂವಿಧಾನದಲ್ಲಿ, ಅದನ್ನು ಯಾರು ಅಲ್ಟಿಮೇಟ್ ಪ್ರೊಟೆಕ್ಟರ್ ಯಾರಾದ್ರದ್ದು? ಆಪ್ಷನ್ ಎ ಪಾರ್ಲಿಮೆಂಟ್, ಆಪ್ಷನ್ ಬಿ ಪ್ರೆಸಿಡೆಂಟ್, ಆಪ್ಷನ್ ಸಿ ಅಟಾರ್ನಿ ಜನರಲ್ ಆಫ್ ಇಂಡಿಯಾ, ಆಪ್ಷನ್ ಡಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಸೊ ದ ಆನ್ಸರ್ ಈಸ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಆಲ್ವೇಸ್ ರಿಮೆಂಬರ್ ದಿಸ್. ಯಾವುದೇ ಕರ್ನಾಟಕ ಪಬ್ಲಿಕ್ ಸರ್ವಿಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ಸ್ ಆಗಲಿ, ಯಾವುದೇ ಕಾಂಪಿಟೇಟಿವ್ ಎಕ್ಸಾಮಿನೇಷನ್ಸ್ ಆಗಲಿ, ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ ಎಕ್ಸಾಮಲ್ಲಿ ಯೂಸ್ ಮಾಡೇ ಮಾಡ್ತಾರೆ. ದ ultimate guarantor of fundamental rights is Supreme Court, the highest court in India. Supreme Court, it is the ultimate guarantor. Any of your fundamental rights is violated, you can directly go to Supreme Court. Supreme Court will protect your fundamental rights by issuing writs under Article 32. ಅರ್ಥ ಆಗ್ತಿದೆಯಾ? Why Supreme Court is the ultimate guarantor of fundamental rights of people? Because it has Article 32 with it, which is constitutional remedies, which we will be discussing in the upcoming classes. Jyoti ma'am, yes ma'am, see Supreme Court. And third point is, they are not sacrosanct. Ade first point de, idu innond meaning ashte. Fundamental rights are not sacrosanct, meaning fundamental rights is not something which no one can touch. Absolutely, Parliament can touch. Fundamental rights are not sacrosanct. The Parliament can curtail or repeal only by constitutional amendment without affecting the basic structure of the Constitution. Are you understanding? We saw fundamental right is not absolute but qualified, meaning state can impose reasonable restrictions on them. ಅಗತ್ಯ ಬಿದ್ದಾಗ, ಸಮಯ ಬಂದಾಗ ಭಾರತ ಸರ್ಕಾರ ಜನರ ಪ್ರಜೆಗಳ ಮೂಲಭೂತ ಹಕ್ಕುಗಳ ಮೇಲೆ ಲಿಮಿಟ್ ಮಾಡ್ಬೋದು, ರೆಗ್ಯುಲೇಟ್ ಮಾಡ್ಬೋದು, ಅದನ್ನು ಕಸಿಸ್ಕೊಳ್ಬೋದು. ಸೆಕೆಂಡ್ ಪಾಯಿಂಟ್ ಏನು ನೋಡಿದ್ವಿ? ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಸ್ ದ ಅಲ್ಟಿಮೇಟ್ ಪ್ರೊಟೆಕ್ಟರ್ ಆಫ್ ದ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ಆರ್ ಗ್ಯಾರಂಟರ್ ಆಫ್ ದ ಫಂಡಮೆಂಟಲ್ ರೈಟ್. ನಿಮಗೆ ಏನೇ ಅನ್ಯಾಯ ಆಗಿರಲಿ, ಮೂಲಭೂತ ಹಕ್ಕುಗಳಿಂದ ಅದರಿಂದ ನಿಮ್ಮ ಏನೇ ಮೋಸ ಆಗಿರಲಿ, ಅಲ್ಟಿಮೇಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ನೀವು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕದ ತಟ್ಟಿದ್ರೆ ಖಂಡಿತ ಅದು ನಿಮ್ಗೆ ನ್ಯಾಯ ಕೊಡುತ್ತೆ, ವ್ರಿಟ್ಸ್ ಇಶ್ಯೂ ಮಾಡುತ್ತೆ. ಯಾರು ಕೂಡ ನಿಮ್ಮ ಮೂಲಭೂತ ಹಕ್ಕುಗಳನ್ನು ಕಸಿದ್ಕೊಳ್ಳೋಕ್ಕಾಗಲ್ಲ ಅಂಡರ್ ನಾರ್ಮಲ್ ಕಂಡೀಷನ್ಸ್. ಥರ್ಡ್ ಪಾಯಿಂಟ್ ಆಸ್ ವಿ ನಟ್, ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ಆರ್ ನಾಟ್ ಸ್ಯಾಕ್ರೋಸೆಂಟ್. ಅಂದರೆ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ ಪೂರ್ತಿ ಪವಿತ್ರವಾದದ್ದಲ್ಲ, ಯಾರು ಮುಟ್ಟಕ್ಕಾಗದಿರೋಷ್ಟು ಪವಿತ್ರವಾದಲ್ಲ. ಯಾಕಂದರೆ ನಮ್ದು ಏನಿದೆ ಸಂಸತ್, ಲೋಕಸಭೆ, ರಾಜ್ಯಸಭೆ, ಅದು ಮುಟ್ಬೋದು. ದ ಪಾರ್ಲಿಮೆಂಟ್ ಕ್ಯಾನ್ ಕರ್ಟೈಲ್ ಆರ್ ರಿಪೀಲ್ ಓನ್ಲಿ ಬೈ ದ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಅಮೆಂಡ್ಮೆಂಟ್. ಮುಟ್ಟಿದ್ರೂ ಸುಮ್ಮನೆ ಸಿಂಪಲ್ ಆರ್ಡಿನರಿ ಪ್ರೊಸೆಸಲ್ಲಿ ಮುಟ್ಟೋದಕ್ಕಾಗಲ್ಲ. ಫಂಡಮೆಂಟಲ್ ರೈಟ್ನ ಚೇಂಜ್ ಮಾಡ್ತಿದೆ ಅಂದರೆ ನಮ್ಮ ಏನು ಪಾರ್ಲಿಮೆಂಟ್, it has to do constitutional amendment under Article 368. Remember students, constitutional amendment. Because fundamental rights is mentioned in the Constitution and it forms the basic structure of the Constitution, Parliament cannot proceed with the ordinary procedure. Parliament only through constitutional amendment it can repeal or curtail the fundamental rights, that too without affecting the basic structure of the Constitution. ಅರ್ಥ ಆಗ್ತಿದೆಯಾ? And fourth point, all fundamental rights, I told you during the time of emergency, all fundamental rights can be suspended except fundamental right Article 20 and 21. What is Article 20 and 21? Diana ma'am, please tell me what is Article 20 and 21. Allu KSP sir, unlucky sir, ಬಸವನ ಬಾಗೆ ಮಾಡಿ ಕ್ಲಾಸ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿರಿ, ಹೇಳ್ರಿ ಇವಾಗ. ಆರ್ಟಿಕಲ್ 20 ಹಾಗೂ ಆರ್ಟಿಕಲ್ 21 ಏನದು? during time of emergency, any emergency, especially during time of national emergency, all articles can be suspended except Article 20 and 21. So what are Article 20 and 21? Article 20 talks about protection in respect to conviction of offenses. ಅಂದರೆ ಏನು ಅರೆಸ್ಟ್ ಪ್ರೊಸೀಜರ್ ಇದೆ, ಒಬ್ಬ ವ್ಯಕ್ತಿ ಯಾರು ಇಲ್ಲಿಗಲ್ ಆಕ್ಟಿವಿಟೀಸಲ್ಲಿ ಪಾಲ್ಗೊಳ್ತಾನೆ ಅವನ್ನ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ ಅರೆಸ್ಟ್ ಆಗಿರೋ ವ್ಯಕ್ತಿಗೆ ಏನು ರೈಟ್ಸ್ ಇದೆ, 24 ಗಂಟೆ ಒಳಗಡೆ ಅವ್ರನ್ನ ಮೆಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ ಒಪ್ಪಿಸ್ಬೇಕು ಪೊಲೀಸವರು, ಹಾಗೂ ತನ್ನ ಮೇಲೆ ತಾನೇ ಸಾಕ್ಷಿ ಹೇಳ್ಕೊಳಕ್ಕಾಗಲ್ಲ. ಈ ಥರ ಎಲ್ಲ ಅದು ಮುಂದೆ ನೋಡ್ತೀವಿ. In future will be, in the upcoming session we will be learning about what Article 20 is, but as per now you have to keep in mind that all fundamental rights can be suspended during the time of emergency except Article 20 and Article 21. Article 21 is protection of life and liberty. Article 20 and 21, no matter what emergency it is, it can't be suspended. And also Article 19. What is Article 19? ಲಕ್ಷ್ಮೀ ಅರುಣೋದಯ 20 ಅಪರಾಧಿಗಳಿಗೆ, ಹೌದು ಮೇಡಮ್, ಹೌದು, ನಾನು ಆಗಲೇ ಹೇಳ್ದಂಗೆ ಪ್ರೊಟೆಕ್ಷನ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ಕನ್ವಿಕ್ಷನ್ ಆಫ್ ಅಫೆನ್ಸಸ್. ಆರ್ಟಿಕಲ್ 20 ಅಂಡ್ ಆರ್ಟಿಕಲ್ 21 ಪ್ರೊಟೆಕ್ಷನ್ ಆಫ್ ಲೈಫ್ ಅಂಡ್ ಲಿಬರ್ಟಿ. ಅಲ್ಲಕ್ಕಿ ಸರ್, ಹೌದು, ಜೀವಿಸುವ ಹಕ್ಕು. ಅಲ್ಲೂ KSP ಸರ್, ಜೀವಿಸುವ ಹಕ್ಕು, ಕರೆಕ್ಟ್. ಅಪ್ಪು ಇನ್ಸ್ಪಿರೇಷನ್, ಜಾತ್ರಾ. ಸೊ Article 19 it talks about your freedom. There are 6 right to freedoms under Article 19. ಹಳೆ ಕ್ಲಾಸಲ್ಲಿ ನಾನು ನಿಮ್ಗೆ ಹೇಳಿದ್ದೆ ಆರ್ಟಿಕಲ್ 19 ಏನರ ಬಗ್ಗೆ ಹೇಳುತ್ತಪ್ಪ ಅಂದರೆ ನೀವೆಲ್ಲರೂ ಹೇಳಿದ್ರಿ ಸರ್ ಫ್ರೀಡಮ್ ಆಫ್ ಸ್ಪೀಚ್ ಆ್ಯಂಡ್ ಎಕ್ಸ್ಪ್ರೆಷನ್, ಫ್ರೀಡಮ್ ಆಫ್ ಸ್ಪೀಚ್ ಆ್ಯಂಡ್ ಎಲ್ಲರೂ ಅದನ್ನೇ ಹೇಳಿದ್ರಿ. ನಾನು ಆಗ ಹೇಳಿದ್ದೆ ಆರ್ಟಿಕಲ್ 19ನಲ್ಲಿ ಬರೀ ಫ್ರೀಡಮ್ ಆಫ್ ಸ್ಪೀಚ್ ಆ್ಯಂಡ್ ಎಕ್ಸ್ಪ್ರೆಷನ್ ಮಾತ್ರ ಇಲ್ಲ, ಒಟ್ಟು ಅಂಡರ್ ಆರ್ಟಿಕಲ್ 19 ಅಂಡರ್ ಫ್ರೀಡಮ್ ದೇರ್ ಆರ್ 6 ಟೈಪ್ಸ್ ಆಫ್ ಫ್ರೀಡಮ್. ನೀವೆಲ್ಲ ಆರ್ಟಿಕಲ್ 19 ಅಂತ ಹೇಳಿದಾಗ ಎಲ್ಲರೂ ಹೇಳ್ತಿರೋದು ಫ್ರೀಡಮ್ ಆಫ್ ಸ್ಪೀಚ್ ಆ್ಯಂಡ್ ಎಕ್ಸ್ಪ್ರೆಷನ್ ಸರ್, ಹಾಲ್ BL ದಲವೈ ಹಾಯ್ ಫ್ರೀಡಮ್ ಆಫ್ ಸ್ಪೀಚ್ ಆ್ಯಂಡ್ ಎಕ್ಸ್ಪ್ರೆಷನ್ ಸರ್ ಅಂತ ಹೇಳ್ತೀರಾ, ಬಟ್ ಬಾಕಿನ 5 ರೈಟ್ಗಳು ಯಾರು ಹೇಳೋದೇ ಇಲ್ಲ. ಎಕ್ಸಾಮಿನರ್ ಅದ್ರ ಬಗ್ಗೆನೇ ಕೇಳೋದು ಎಕ್ಸಾಮಿನಲ್ಲಿ. ಸೊ ವಾಟ್ ಆರ್ಟಿಕಲ್ 19 provision has to with the fundamental right is Article 19 can only be suspended when national emergency is declared based on war or external aggression, but it can't be suspended during internal armed rebellion. ಅರ್ಥ ಆಗ್ತಿದೆಯಾ? ಜ್ಯೋತಿ ಮ್ಯಾಮ್, yes, 6 types. So when national emergency is declared under Article 352, national emergency, when national emergency is declared under Article 352, it can be only declared on following 3 bases. Only on 3 bases national emergency can be declared. First way, when there is war, when India is in war with any country, then national emergency can be declared. Second one, external aggression, meaning in a boundary near the border areas, aggression is taking place from the enemy side. External aggression, yes, national emergency can be declared. Third reason is internal armed rebellion. Inside India only riots are happening, that too armed riots, that too disturbance is happening. So only on three reasons, only because of 3 reasons national emergency can be declared, and that too Article 20 and 21 can only be suspended for first and second reason, that is for war and on external aggression only, whereas Article 19 cannot be suspended because of internal armed rebellion. When national emergency is declared due to internal armed rebellion, Article 19 cannot be suspended, only Article 20 and 21 can be suspended. Diana, 6 freedoms under Article 19. Okay, 6 freedoms ಯಾವ್ದು ಅಂತ ಹೇಳ್ತೀರಾ? ವಾಕ್ ಸ್ವಾತಂತ್ರ್ಯ 19, ಕರೆಕ್ಟ್. So please keep it in mind students, whenever someone talks about Article 19, all of you will say freedom of speech and expression, but that is not the only right which we have under Article 19. We have 5 more rights. We have totally we have 6 rights, 6 freedoms under Article 19. Not only one freedom of speech and expression, we have other rights also. Okay, I hope you understood the 4 points or 4 features of fundamental rights. That fundamental rights is not absolute, but qualified state can impose reasonable restrictions on them. Ultimate guarantor of fundamental right is Supreme Court. Fundamental right is not sacrosanct, that Parliament can impose or curtail or repeal through constitutional amendment without affecting the basic structure of the Constitution. And in fundamental right, all articles can be suspended during the time of national emergency except Article 20 and 21, and during time of internal armed rebellion, all Article 20, 21 and 19, 3 also cannot be suspended. I hope you understood. Next topic, go on. So we are there are 6 fundamental rights between Article 14 to Article 32. Article 14, equality of law and equal protection of law. Article 14 to Article 32, constitutional remedies. There are categorized into 6 types of rights. So you just have to remember this, that's all. Right to equality. Right to equality, Article 14 to 18, that is right to equality. Article 19 to 20, that is right 22, right to freedom. Article 23 and 24, it's right against exploitation. Article 25 to 28, it's right to freedom of religion. Article 29 to 30, cultural and educational rights. Right to constitutional remedies is Article 32, that is writs. The writs which we have. So please note down this or take a picture of this or take a screenshot of this. How do unlucky sir? Under Article 19, ಯಾವ ತರ freedom ಇದೆ ನಮಗೆ? Right to form association, right to peacefully assemble at a public place, right to freely reside anywhere in the country, right to freely move throughout the country, right to carry any of our profession of our choice, and right to freedom of speech and expression. These are the 6 right to freedom. These are the 6 rights which are available under Article 19, and also take a good look of this or take a screenshot of this or picture of this. Right to equality, article numbers, right to freedom, article numbers, right against exploitation, right to freedom of religion, right against cultural and educational minorities, right to constitutional remedies. So today we will be dealing with right to equality, Article 14. Article 14 too we will be dealing with, before Article 14, there are 2 more articles. There are 2 more articles before Article 14, and today we will be dealing with them before starting fundamental rights. So today we will be dealing with Article 12, Article 13 and Article 14, very important articles. Article 12 and Article 13 very important. It gives you good understanding before starting with fundamental rights. In order to understand it, you have to understand what is Article 12, Article 13. Only after that you can proceed with fundamental right. So there in citizenship, in our previous classes, Pauratva Bhaga 2, citizenship part 2, last article which we learned in was Article 11 in citizenship part 1. Article 11, after that continuation is Article 12, 13 and 14 we will be learning today. So let's see what Article 12 is. Unlucky, howದು sir? Right to property. Right to property, which was a fundamental right under Article 19, was repealed. 44ನೇ amendment 1978. Okay, we'll come to that in the future. We'll be dealing with it. So let's learn about what Article 12 is. Students, Article 12 talks about definition of the state. Please note down Article 12, definition of the state. Article 12 talks about what is state basically, what all consists of state, what all inside the state, what all consists of state, what is state. Is state and the Rajya Allah, don't get confused. This state is not like Karnataka state, Tamil Nadu, not that state. In polity, when the word state is used, it also means the entire India, the entire government of India, or the entire India, what it consists, it is also called as state. Like how we call India country, it is also called as India state. Don't get confused. This state is not any Tamil Nadu, Karnataka, Maharashtra state. This state means India as a whole. The Indian government, Indian executive, judiciary, legislative, it is as a whole state in polity. Okay. ಈ ಸ್ಟೇಟ್ ಅಂದರೆ ಯಾವುದೇ ರಾಜ್ಯ ಅಲ್ಲ, ಕನ್ಫ್ಯೂಸ್ ಆಗಬೇಡಿ. ಸ್ಟೇಟ್ ಅಂದರೆ ಪೂರ್ತಿ ಭಾರತ ದೇಶದ ಬಗ್ಗೆ ಮಾತಾಡ್ತಿದೆ. ಭಾರತ ದೇಶದಲ್ಲಿರೋ ಸರ್ಕಾರ ಬಗ್ಗೆ, ನ್ಯಾಯಾಂಗ, ಶಾಸಕ, ಕಾರ್ಯನಿರ್ವಾಹಕ ಅವ್ರಗಳ ಬಗ್ಗೆ ಮಾತಾಡ್ತಿದ್ದಾರೆ. ಓಕೆ, ಲೆಟ್ಸ್ ಸ್ಟಾರ್ಟ್. ಆರ್ಟಿಕಲ್ 12, ದ ಡೆಫಿನೇಷನ್ ಆಫ್ ಸ್ಟೇಟ್. ವಾಟ್ ಆಲ್ ಸ್ಟೇಟ್ ಕನ್ಸಿಸ್ಟ್ ಆಫ್? ಸ್ಟೇಟ್ ಕನ್ಸಿಸ್ಟ್ ಆಫ್ legislative and executive organs of the union government, that is Indian government. ಲೆಜಿಸ್ಲೇಟಿವ್ ಅಂದ್ರೆ ಏನು? ಲೆಜಿಸ್ಲೇಟಿವ್ ಆರ್ಗನ್ ಅಂದ್ರೆ ಏನು? ಕನ್ನಡದಲ್ಲಿ ಏನಂತಾರೆ ಲೆಜಿಸ್ಲೇಟಿವ್ ಅಂದ್ರೆ? ಶಾಸಕಾಂಗ. ಲೆಜಿಸ್ಲೇಟಿವ್ ಆರ್ಗನ್ ಶಾಸಕಾಂಗ, ಅಂಡ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಕಾರ್ಯನಿರ್ವಾಹಕ, and also judiciary also comes, that is ನ್ಯಾಯಾಂಗ. So these are organs. Legislative and executive organs of the union government comes under the definition of state, and also the legislative and executive organs of state also comes under definition of the state. So what is the legislative organ of the union government? ಯೂನಿಯನ್ ಗೌರ್ಮೆಂಟ್ನ ಶಾಸಕಾಂಗ ಅಂಗಗಳು ಯಾವುದು? ಇರೋದೇ ಎರಡು, ರಾಜ್ಯಸಭಾ ಅಂಡ್ ಲೋಕಸಭಾ, ದಟ್ ಈಸ್ ಇಂಡಿಯನ್ ಪಾರ್ಲಿಮೆಂಟ್. ಲೋಕಸಭೆ ಹಾಗೂ ರಾಜ್ಯಸಭೆ. And when it comes to state, the legislative organs of the state, we know 6 states in India have bicameral legislature, that is both Vidhana Sabha and Vidhana Parishad. They have bicameral legislature, 6 states in India. Rest of the states, they have only single, that is Vidhana Parishad. So what all comes under the definition of state according to Article 12 is the legislative and executive organs of the union government, that is Rajya Sabha and Lok Sabha, the legislative and executive organs of the state, that is state assemblies, Vidhana Sabha and Vidhana Parishad, and also all local authorities. What are all local authorities? The BBMP, municipalities, BBMPs, Nagar Panchayat, Palikas, corporations, all those government entities, and also panchayats, the Zilla Panchayat, Mandal Panchayat, Gram Panchayat, what all are the entities of the government, they all come under the definition of the state. ಅರ್ಥ ಆಗ್ತಿದ್ಯಾ? ಲೀಜಿಯಾನ್, ನೀವು ನಿಜವಾಗ್ಲೂ ಕೊರಿಯಾದವರಾ? ಓಕೆ, ಲೀಜಿಯಾನ್ ಶಾಸಕಾಂಗ, ಕಾರ್ಯ ನ್ಯಾಯಾಂಗ. ಓಕೆ, ಅರ್ಥ ಆಗ್ತಿದೆಯಾ ಇದು? ವಾಟ್ ಆಲ್ ಕಮ್ಸ್ ಅಂಡರ್ ಡೆಫಿನೇಷನ್ ಆಫ್ ಸ್ಟೇಟ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಆರ್ಟಿಕಲ್ 12 ಈಸ್ ಆಲ್ ದೋಸ್ ಎಂಟಿಟೀಸ್, ವೆದರ್ ಇಟ್ ಈಸ್ ಪಾರ್ಲಿಮೆಂಟ್, ಸ್ಟೇಟ್ ಲೆಜಿಸ್ಲೇಟಿವ್ ಅಸೆಂಬ್ಲೀಸ್, ಅಂಡ್ ಆಲ್ಸೋ ಆಲ್ ದೋಸ್ ಕಾರ್ಪೊರೇಷನ್ಸ್, ಮುನಿಸಿಪಾಲಿಟೀಸ್, ನಗರ ಪಾಲಿಕಾಸ್, ಅಂಡ್ ಆಲ್ ದೋಸ್ ಇವನ್ ಎಂಟಿಟೀಸ್, government entities, like we know BEL, BHEL, BEL, HMT, BMRCL, Bangalore Metro Rail Corporation, any government entity, all those entities which works under government, all those entities comes under the definition of state. Please understand. So any of these people violate your fundamental right, you can go and file case against them in Supreme Court for violating your fundamental right. Anyone, example, say suppose in BHEL or HMT, any government public sector entities, they violated your fundamental right, telling we are hiring only men, no women, we are hiring only men, so that is discrimination based on gender, so they are violating your fundamental right. You can go file the case against them in Supreme Court, against that public sector which is hiring only men, not women. ಅರ್ಥ ಆಗ್ತಿದ್ಯಾ? All those entities which works under government instructions, they fall under the definition of the state under Article 12. If they violate your fundamental right, you can take them to court. Supreme Court ಗೆ ಅವ್ರನ್ನ ತಗೊಂಡು ಹೋಗ್ಬೋದು, ನಾವು ಅವ್ರ ಮೇಲೆ ಕೇಸ್ ಫೈಲ್ ಮಾಡಿ. So question, according to Article 12 of the Indian Constitution, the term state, as I said, the term state includes all of the following except. So what this question is telling, according to the term of Indian Constitution state, among these 4 options, 3 are correct, 1 is wrong, except. So which one is the wrong statement? You need to find it out. Please find it out, students. Does state include the government and the Parliament of India? Does the state include the government and legislature of each of the states? Does the state include all local authorities, example municipalities, panchayats? Does the state include any private individual or private organization not exercising public functions. Please answer, students. Just now we learned about Article 12. What are Article 12 consist of? We learned it. And the question is based on that article only. It is asking which among the following statements are wrong. ಈ 4 ಆಪ್ಷನ್ಸ್ ಅಲ್ಲಿ ಯಾವ ಆಪ್ಷನ್ ಅಲ್ಲಿ ಏನು ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ ಅದು ಆರ್ಟಿಕಲ್ 12 ಡೆಫಿನೇಷನ್ ಸ್ಟೇಟ್ ಅಂಡರ್ ಬರಲ್ಲ. ಎಫ್ ಜೆ ಎಫ್ ಟಿ ಡಿ ಆಪ್ಷನ್ ಸಿ. ಆಪ್ಷನ್ ಸಿ ಕನ್ಫ್ಯೂಸ್ ಆಗಿ ಆಗ್ತಿದ್ದೀರಾ. ಸಮ್ ಪೀಪಲ್ ಆರ್ ಕನ್ಫ್ಯೂಸ್ ಬಿಟ್ವೀನ್ ಆಪ್ಷನ್ ಸಿ ಅಂಡ್ ಆಪ್ಷನ್ ಡಿ. ವೈ? Diana ma'am, D correct. Lakshmi Arunadaya, D correct. Ria ma'am, I think you didn't attend our previous classes. You just attended one class and you disappeared. Now you are back. Okay. Unlucky, you are asking me D question mark. Students, why are you getting confused between C and D? What does C option tell? All local authorities, example, municipalities, panchayats. What about option D? It is talking about any private individual or private organization. What did I just teach you in the previous slide? I repeated multiple times. Definition of state along with the parliament in the center and state legislative assemblies, it also include all local authorities. That is municipality, your BBMP. If you are staying in Bangalore, it is BBMP. Wherever you are staying, there will be some municipal corporation to clear the garbage, to lay roads, electricity. There are Nagar Panchayats, Nagar Palikas, municipalities, corporation, Gram Panchayat, Mandal Panchayat. All these panchayats come under the definition of all these government entities come under the definition of state. So why are you going with option C? Why are you going with option C? Option C is correct. Option A is correct. Option B is correct. Option C is correct. The wrong one is option D, because option D is talking about any private individual or private organization not exercising public function. Why will private individual or private organization exercise public function? Why should he do it? Any organization which is working under the government, then it has to do it. But any private individual or private organization not exercising public functions, yeah, that is wrong. That does not come under the definition of state. These 3 statements come under the definition of state according to Article 12. Please read it once. The government and the Parliament of India, definitely it comes under the definition of term state under Article 12. The government and legislature of each of the states, yes, it should come under the definition of Article 12 states. And also all local authorities, obviously, because all these local authorities also, they are formed based on their provisions mentioned in the Constitution. But private company, to open a private company, is there any provision mentioned in the Constitution? No. Private company will go according to the Companies Act. There is no mention of private company, how to open a private company, what are the licenses to be required, what are the procedures. It is not mentioned in the Constitution of India. To open a company, to register a company, you need to follow the Companies Act, not Constitution. So obviously this is a wrong answer. Don't get confused, students. Jyoti ma'am, D correct. So we learned about Article 12, that is definition of state, what all consists of state under the term state. Now let's learn about what is Article 13. Yes students, let's learn about Article 13. What Article 13 tells is laws that are inconsistent with the fundamental rights are invalid. So I told you, I repeated 100 times telling that if any law which violates your fundamental rights, it is invalid. It is repealed, deleted from the Constitution. Now who gave you that right? Who gave Constitution that right? That is already mentioned in the Constitution under Article 13. Under Article 13, Article 13 gives power to judiciary, to Parliament, that is Lok Sabha and Rajya Sabha, that any fundamental right which is violating the right, any article which is violating the fundamental right of a citizen of India, then that law should be deleted or changed. That what Article 13 is talking about. Laws inconsistent with the fundamental rights are invalid, that they can be deleted. Article 13 gives that power. So we'll see what are those laws. It is just telling laws. Article 13 is just telling laws which are inconsistent with the fundamental rights. Now what are those laws? Because laws is a broad concept. Everything passed is under law. Let's see what all those consist of laws. Laws are those laws expressively provides, meaning, see, Article 13 laws, as I said, it declares all laws inconsistent with the fundamental rights shall be void. Example, right to property. Right to property. Unlucky sir, right to property, which was a fundamental right under Article 19. Under Article 19 it was a fundamental right. Later in the 44th amendment, 44th Constitutional Amendment Act 1978, it was repealed. Fundamental right, what property, right to property was there under Article 9. In the 44th Constitutional Amendment Act 1978, it became a legal right. Under Article 300A, Part 12. See, who gave Constitution the power, who gave the Parliament power to change the right to property from fundamental right to legal right? It is in the Constitution by Article 13. Article 13 in the Constitution gives judiciary and Parliament the power to change, delete, repeal those articles which violates the fundamental rights. You might be wondering who is that person in the background. That person, you will be knowing his name also, is Keshavananda Bharati. The famous case which shook the judiciary, the Indian Constitution. ಭಾರತ ಸಂವಿಧಾನನೇ ಅಲ್ಲಾಡಿಸುತ್ತೆ ಈ ಕೇಸ್. ಇವನ್ ಭಾರತದ ನ್ಯಾಯಾಂಗ ಕೂಡ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನ ಕೂಡ ಅಲ್ಲಾಡಿಸುತ್ತೆ. ಅದು ಕೇಶವಾನಂದ ಭಾರತಿ ಕೇಸ್ 1973. ದ ಕೇಶವಾನಂದ ಭಾರತಿ ಕೇಸ್ 1973. So this is that person, Kesavananda person. So we will be discussing about in future. As of now, we have to keep it in mind that Article 13 gives power to Parliament and Judiciary to repeal or delete or change the law which is violating the fundamental right of the people. So good example is right to property. Right to property was violating the fundamental rights of the people. So it was through 44th Constitutional Amendment Act 1978, from fundamental right it was converted to legal right. Today also we have right to property, but that right to property is not a fundamental right today. It is a legal right under Article 300A. It is under Part 12. Fundamental right is under Part 3. That is legal right, which is right to property. Today it is under Part 12, Article 300A. Diana ma'am, yes. Yes. IU 1973. Yes. Kesavananda Bharati, Jyoti ma'am, yes, correct. So Article 13 expressively provides for doctrine of judicial review. I told you, I repeated the point multiple times, telling that Article 13 gives power to both judiciary and Parliament to change those laws which are violating fundamental rights. What is that power given to judiciary is called as? That is called as doctrine of judicial review. See, in the name only, ಹೆಸರಲ್ಲೇ ಇದೆ judicial review ಅಂದ್ರೆ ಏನಪ್ಪ? ಒಂದು ಸಾರಿ ಸಂಸತ್ತಲ್ಲಿ ಬಿಲ್ ಪಾಸ್ ಆಗಿ ಯಾವ್ದಾದ್ರು ಲಾ ಮಾಡಿದಾಗ ಇಂಡಿಯನ್ ಪಾರ್ಲಿಮೆಂಟ್ ಏನಿದೆ, ಭಾರತದ ಪಾರ್ಲಿಮೆಂಟ್ ಏನಿದೆ, ಸಂಸತ್ ಒಂದು ಲಾನ ಜಾರಿಗೊಳಿಸಿದಾಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂಟರ್ವ್ಯೂನ್ ಮಾಡಿ ಇಲ್ಲ ಹೈಕೋರ್ಟ್ ಇಂಟರ್ವ್ಯೂನ್ ಮಾಡಿ ಜುಡಿಷಿಯಲ್ ರಿವ್ಯೂ ಮಾಡ್ಬೋದು. ಇವ್ರು ಏನು ಒಂದು ಇವತ್ತು ಲಾ ಮಾಡಿದ್ದಾರೆ, ಅದು ನಮ್ಮ ಪ್ರಜೆಗಳಿಗೆ ಸೂಕ್ತನಾ ಇಲ್ಲ ಅವ್ರದ್ದು ಯಾವ್ದಾದ್ರು ಮೂಲಭೂತ ಹಕ್ಕುಗಳನ್ನು ಅದು ವಯೋಲೇಟ್ ಮಾಡ್ತಿದ್ಯಾ ಅಂತ ಜುಡಿಷಿಯಲ್ ರಿವ್ಯೂ ಮಾಡ್ಬೋದು ಆ ಆರ್ಟಿಕಲ್. ಆಮೇಲೆ ನಾಳೆ ದಿನ ಸಂಸತ್ತು ಜುಡಿಷಿಯರಿ ಜೊತೆ ಫೈಟಿಂಗ್ ಹೋದರೆ ಇಫ್ ದ ಪಾರ್ಲಿಮೆಂಟ್ fights against the judiciary telling that you don't have any right to intervene whatever law I pass, now the judiciary can tell, dear parliament, please look in the Indian constitution under article 13. Article 13 gives judiciary the power of judicial review in order to review any law passed by the parliament if they are violating the fundamental right of the constitution. See, under judicial review, both Supreme Court and High Court and Supreme Court, both Supreme Court and High Court can declare a law unconstitutional and void on the ground of violating the fundamental right. ಅರ್ಥ ಆಗ್ತಿದ್ಯಾ? Very much right. Very much right. In Salient Features of Indian Constitution, if you go back and watch our previous sessions based on Salient Features of Indian Constitution, fundamental rights were borrowed from USA, the Constitution of USA. Those who have missed our previous classes, those who are new or watching our class for the first time, please go back and watch our previous classes where we have learned that fundamental rights were borrowed from the USA, United States of American Constitution. And what Article 13 is? Article 13 tells that those laws which are violating fundamental rights are inconsistent, they can be deleted, changed or repealed. They can be deleted, changed or repealed by whom? Supreme Court and High Court through doctrine of judicial review, and also to Parliament. Parliament can also pass constitutional amendment, like how they passed right to property, 44th Constitutional Amendment Act 1978. How Constitution, they passing 44th Constitutional Amendment Act 1972, they converted right to property to a legal right. So both Parliament and judiciary have right to delete, change or repeal any law that is violating the fundamental right of people. ಅರ್ಥ ಆಯ್ತಾ? So question, please read the question and answer, students. Article 13 of the Indian Constitution deals with laws inconsistent with or in derogation of the fundamental rights. This article essentially provides doctrine of what? Just now we learned. Which doctrine? Separation of powers, parliamentary sovereignty, judicial review, basic structure. Which doctrine? Diana ma'am C, Ria ma'am C, Jyoti ma'am C, Lakshmi Arunodaya C, Unlucky C. Okay, very good. Judicial review. Okay, this one was easy. Under Article 13, to judiciary the power is given, the doctrine of judicial review, but to whom and all it is given? Whether is it given to only Supreme Court or both Supreme Court and High Court or even district courts? No, in India we have 4 types of courts, 4 stages, we can say 4 authorities of court, that is lower court, district court, High Court, Supreme Court. So the Indian Constitution, which gives the doctrine of judicial review under Article 13, to which and all courts does it give? ಈ 4 courts ಅಲ್ಲಿ ಎಲ್ಲರ 4 courtsಗೂ ಇದೆಯೇನಪ್ಪ? Lakshmi Arunodaya, Supreme Court, High Court. Okay, what about others? Do you agree with her? Or do you also say, no sir, even district court and lower court also have the power to judicially review the laws made by the parliament? Come on, answer please. Jyoti, Supreme Court, High Court, correct ma'am. Lakshmi Arunodaya, Supreme Court and High Court, correct ma'am. So only Supreme Court and High Court. Supreme Court under Article 32. Supreme Court under Article 32. High Court under Article 226. Only Supreme Court and High Court, using these 2 articles, they can judicially review any law made by the parliament. Lower court and district court, they don't have that power. Understood? Supreme Court Article 32 constitutional remedies, High Court under Article 226. Ria ma'am, yes, 32. Diana ma'am, yes, both High Court and Supreme Court, correct. So please remember this, examiner can easily trick you. Examiner can use only Supreme Court has the right under Article 13. Only Supreme Court has got doctrine of judicial review. That statement is wrong. Both Supreme Court and High Court has got doctrine of judicial review under these respective articles. ಅರ್ಥ ಆಗ್ತಿದ್ಯಾ? IU 32,226 correct. Correct IU. So in the previous slide we saw what all Article 3 does is, Article 13 does is, Article 13 declares laws inconsistent with the fundamental rights shall be void, and Article 13 expressly provides for doctrine of judicial review for both Supreme Court and High Court. We saw what Article 13 gives powers, empowers, but we haven't learnt yet what laws means, what all consist of laws. So here we will be learning laws ಕೆಳಗಡೆ ಏನಪ್ಪ ಬರ್ತಿದೆ, what all consist under definition of law under Article 13. ಆರ್ಟಿಕಲ್ 13 ಕೆಳಗಡೆ ಏನು ಲಾ ಇದೆ, ಲಾ, ಆ ಲಾ ಕೆಳಗಡೆ ಏನೇನೆಲ್ಲ ಬರ್ತವೆ. ಫಸ್ಟ್ ಒನ್, ಪರ್ಮನೆಂಟ್ ಲಾಸ್ ಎನಾಕ್ಟೆಡ್ ಬೈ ಪಾರ್ಲಿಮೆಂಟ್ ಆರ್ ಸ್ಟೇಟ್ ಲೆಜಿಸ್ಲೇಚರ್ಸ್. ಪರ್ಮನೆಂಟ್ ಲಾಸ್ ವಿಚ್ ಆರ್ ಎನಾಕ್ಟೆಡ್ ಇನ್ ದ ಪಾರ್ಲಿಮೆಂಟ್ ಬೈ ಲೋಕಸಭಾ and the Rajya Sabha or the state legislature. Those laws come under the definition of law under Article 13. Temporary laws like ordinance issued by the president or state governors. ಏನಪ್ಪ ಇದು ಸರ್ is talking about permanent law and temporary law, ಆ ಥರ ಲಾಗಳಿದೆಯಾ? ಎಸ್ ಸರ್, ಎಸ್. Parliament in whatever laws which are passed today, there are permanent laws. Like example, permanent laws are those laws once passed it is not deleted or which is not taken back. Permanent laws passed by both Lok Sabha and Rajya Sabha and approved by the president, or in the state it is passed by the state legislative assembly, approved by the governor, it becomes law. Those are permanent law. What do you mean by temporary law? Temporary law are called ordinances. ಏನಪ್ಪ ordinances ಅಂದರೆ ಕನ್ನಡ ಸ್ಟೂಡೆಂಟ್ಸ್ ಹೇಳಿ, ಎಸ್ಪೆಷಲಿ ಕನ್ನಡ ಸ್ಟೂಡೆಂಟ್ಸ್ or ತಮಿಳ್ನಾಡು ಸ್ಟೂಡೆಂಟ್ಸ್, there was a fight going on in between governor and the ruling party of the states. Please tell me, what do you mean by ordinances? ಕನ್ನಡದಲ್ಲಿ ಏನಂತಪ್ಪ ಆರ್ಡಿನೆನ್ಸ್ ಅಂದರೆ, ಇನ್ ಕನ್ನಡದಲ್ಲಿ ಆರ್ಡಿನೆನ್ಸ್ಗೆ ಸುಗ್ರೀವಾಜ್ಞೆ ಅಂತ ಹೇಳ್ತಾರೆ. ವಾಟ್ ಡು ಯು ಮೀನ್ ಬೈ ಆರ್ಡಿನೆನ್ಸ್? ಆರ್ಡಿನೆನ್ಸ್ ಇಸ್ ಅ ಪವರ್ ಯೂಸ್ಡ್ ಬೈ ಗವರ್ನರ್ಸ್ ಆರ್ ದ ಪ್ರೆಸಿಡೆಂಟ್ ವೆನ್ ದ legislative organs are not in session, meaning when the Lok Sabha and Rajya Sabha, when the Lok Sabha and Rajya Sabha is not in the session, they are on the holiday, then president can issue ordinance and pass any law. Same way in state also. In state, if Vidhana Sabha is not in session, which is in holiday, governor can issue ordinance and pass the law, but that is temporary, because once the parliament comes back from the holiday, once the state legislative assemblies come back from the holiday, they have to pass the ordinance whichever issued by the governor or president, or else that ordinance will expire after 6 months and 6 weeks. 6 months and 6 weeks. ಅರ್ಥ ಆಗ್ತಿದ್ಯಾ? in upcoming classes under president, under governor, we will be learning about completely about ordinances. As of now, please understand, ordinance is nothing but whenever the house, whether it is parliament that is in center or in state, whenever the house is not in session, which is on holiday, the president or governor can issue or make a law through issuing ordinances, and that ordinances will later should be approved by the houses after coming back from the holiday. If it is not approved after 6 months and 6 weeks, it is expired. That is why it is temporary. No, maximum period for ordinance is 6 months and 6 weeks. If it is not passed, it is expired after that. So it is temporary. So this is what temporary laws is. C, statutory instruments. Statutory instruments in the nature of delegated legislation like order, bylaw, rule, regulation and modification. So in statutory instruments or order, bylaw, all these orders, all these executive orders passed by the executive organs, not only the laws made by the parliament, not only the ordinances issued by president or governor, but also the statutory instruments. Statutory instruments ಅಂದ್ರೆ ಏನು? Statutory instruments ಅಂದ್ರೆ ಏನು ಕಾಯ್ದೆಗಳಿದೆ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆರ್ಗನ್ಸ್ ಕಾಯ್ದೆಗಳು, ಆಬ್ವಿಯಸ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆರ್ಗನ್ಸ್ ಇಫ್ ದೇ ವಾಂಟ್ ಟು ಫಂಕ್ಷನ್ ದೇ ಹ್ಯಾವ್ ಟು ಪಾಸ್ ಆರ್ಡರ್, ಸರ್ಟೆನ್ ಆರ್ಡರ್ಸ್ ಆನ್ ಹೌ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಆಡಳಿತ ಹೇಗೆ ನಡೆಸಬೇಕು ಅಂತ ಆರ್ಡರ್ಗಳು ಪಾಸ್ ಆಗ್ತವೆ ಡೇ ಬೈ ಡೇ. ಸೊ ಇವನ್ ಆಲ್ ದೀಸ್ ಆರ್ಡರ್ಸ್ ಆಲ್ಸೋ ದೇ ಕಮ್ ಅಂಡರ್ ದ ಡೆಫಿನೇಷನ್ ಆಫ್ ಲಾ. ಇಫ್ ಎನಿ ಆಫ್ ದೋಸ್ ಆರ್ಡರ್ಸ್ ದೇ ವಯೋಲೇಟ್ ದ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ಆಫ್ ಎನಿ ಇಂಡಿಯನ್ ಸಿಟಿಸನ್, ದಟ್ ಈಸ್ ವಾಯ್ಡ್, ದಟ್ law can be deleted. ಅರ್ಥ ಆಗ್ತಿದ್ಯಾ? And also non-legislative sources of law, that is custom usage having the force of law. So basically students, just note down, understand or by heart only these 4 points. What all comes under definition of law? Under definition of law, under Article 13, permanent laws, temporary laws, customary laws, and also order, bylaw or statutory instruments. These four categories of laws comes under definition of law under Article 13. Okay sir, you are talking about only these 4 laws, that is permanent law, temporary law, statutory instrument, customary law, these 4 laws. Then what about the constitutional amendment? Even constitutional amendment is also law, right? Then what about the constitutional amendment? Article 13 there is no mention about constitutional amendment. It is only Article 13 has only mentioned about permanent law, temporary law, statutory instrument and customary law. Only about these 4 Article 13 has mentioned. Then what about constitutional amendment law? About constitutional amendment law, Supreme Court gave a verdict. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಒಂದು ವರ್ಡಿಕ್ಟ್ ಕೊಡುತ್ತೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಬಗ್ಗೆ. ಯಾಕಂದರೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಮೆಂಡ್ಮೆಂಟ್, ಸಂವಿಧಾನ ಅಮೆಂಡ್ ಆದಾಗ ಅಮೆಂಡ್ ಏನಾಗಿರುತ್ತೆ ಅದು ಭಾರತೀಯ ಪ್ರಜೆಗಳದ್ದು ಮೂಲಭೂತ ಹಕ್ಕುಗಳನ್ನು ವಯೋಲೇಟ್ ಮಾಡ್ತಿದ್ರೆ ಮತ್ತು ಅದಕ್ಕೆ ಯಾರು ನ್ಯಾಯ ಕೊಡಿಸೋರು? ಆರ್ಟಿಕಲ್ಸಲ್ಲಿ ಅದ್ರ ಬಗ್ಗೆ ಮೆನ್ಷನ್ ಇಲ್ವಲ್ಲ. ಸೊ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇನ್ 1951, ಪ್ಲೀಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್, ದಿಸ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ and the cases also please understand. Supreme Court in 1951 in Shankari Prasad versus Union of India. Which case? Shankari Prasad versus Union of India 1951 case. In this case, Supreme Court, it gave verdict telling that constitutional amendment is not a law. So constitutional amendment, it doesn't come under Article 13. So it can violate any fundamental right of citizens. Understanding? In Shankari Prasad versus Union of India case 1951, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಒಂದು ತೀರ್ಪು ಕೊಡುತ್ತೆ. ಏನಪ್ಪ ಅಂದರೆ, ಸಂವಿಧಾನನ ತಿದ್ದುಪಡಿ ಏನು ಮಾಡ್ತೀರಾ, ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಮೆಂಡ್ಮೆಂಟ್, ಸಂವಿಧಾನದ ತಿದ್ದುಪಡಿ ಏನು ಮಾಡ್ತೀರಾ ಅಂಡರ್ ಆರ್ಟಿಕಲ್ 368, ದಟ್ ಕ್ಯಾನ್ ವಯೋಲೇಟ್ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ಆಫ್ ಪೀಪಲ್. ಸಂವಿಧಾನದ ತಿದ್ದುಪಡಿಗೆ ಪ್ರಜೆಗಳ ಮೂಲಭೂತ ಹಕ್ಕುಗಳೇನಿದೆ ಅದನ್ನು ಕಸಿದುಕೊಳ್ಬೋದು. ಆ ಥರ ತೀರ್ಪು ಕೊಡುತ್ತೆ 1951 ಶಂಕರಿ ಪ್ರಸಾದ್ ವರ್ಸಸ್ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ ಕೇಸಲ್ಲಿ. ಲೇಟರ್ ಇನ್ ಕೇಶವಾನಂದ ಭಾರತಿ ಕೇಸ್ ಇನ್ 1973, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತನ್ನ ತೀರ್ಪನ್ನೇ ಬದಲಾಯಿಸುತ್ತೆ. ಏನು ಹೇಳಿತಪ್ಪ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಂದರೆ, 1951 ಶಂಕರಿ ಪ್ರಸಾದ್ ವರ್ಸಸ್ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ ಕೇಸಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಗ ತೀರ್ಪು ಕೊಟ್ಟಿತ್ತು. ಏನಂತ, ಭಾರತ ಸಂವಿಧಾನದ ತಿದ್ದುಪಡಿ ಆರ್ಟಿಕಲ್ 13 ಅಂಡರಲ್ಲಿ ಬರೋದಿಲ್ಲ, ಅದು ಯಾವುದೇ ಪ್ರಜೆಗಳನ್ನ ಮೂಲಭೂತ ಹಕ್ಕುಗಳನ್ನು ಕಸಿದುಕೊಳ್ಬೋದು ಅಂತ. ಆದರೆ ಇವಾಗ ನಾವು 1973 ಇದು ಕೇಶವಾನಂದ ಭಾರತಿ ಕೇಸ್ ವರ್ಸಸ್ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ. ಇದರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದರೆ, ನಾವು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಮ್ಮ ತೀರ್ಪನ್ನೇ ಬದಲಾಯಿಸ್ಕೊತಿದ್ದೀವಿ. ಏನಂದರೆ, ಸಂವಿಧಾನದ ತಿದ್ದುಪಡಿ ಅಂಡರ್ ಆರ್ಟಿಕಲ್ 13 ಬರುತ್ತೆ, ಹಾಗೂ ಅದನ್ನು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಕ್ಯಾನ್ violate the fundamental rights without affecting the basic structure of the constitution. Are you understanding, students? In constitution there are certain articles which forms the basic structure of the constitution. This is judicially innovated. In constitution, ಭಾರತ ಸಂವಿಧಾನದಲ್ಲಿ ಬೇಸಿಕ್ ಸ್ಟ್ರಕ್ಚರ್ ಆಫ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಯಾವ್ದಪ್ಪ ಅಂದರೆ ಎಲ್ಲೂ ಮೆನ್ಷನ್ ಆಗಿಲ್ಲ. There is nowhere in the constitution it is mentioned what all comes under basic structure of the constitution. It is the judiciary, it is the Supreme Court and High Court. This judiciary, they have categorized some of the articles as basic structure of the constitution, like secularism, democracy, Article 14, equality of law, fundamental rights, all these forms basic structure of the constitution that is categorized by Supreme Court and High Court. Nowhere in the constitution it is mentioned what is basic structure of the constitution. So in Kesavananda Bharati case 1973, Supreme Court gave a verdict telling that even constitutional amendment falls under the category of laws under Article 13, but it can be constitutional amendment, it can happen without violating the fundamental rights which are forming the basic structure of the constitution. Yes, IU, President, the power of ordinance making power, President 123, Governor 213, correct. Okay. Question, which of the following statements regarding Article 13 is correct? Which of the statements under Article 13 is correct? It declares that all laws in force in India immediately before the commencement of the constitution are void if they are inconsistent with fundamental rights. It mandates that states shall not make any laws which takes away, abridges the rights of conferred by Part 3. It defines law to include any ordinance, order, bylaw, rule, regulation, notification, custom or usage having the territory of India in force of the law, or all of the above. Please read the question once again, students, and let me know the answer. Which of the following statements regarding Article 13 is correct? What do you mean by, what does Article 13 speak about? Option A, B, C or D, option all of the above. Just see the whatever we learned in under Article 13. Under Article 13 we learned any law which is violating the fundamental rights of the people is inconsistent, it has to be repealed. Even if that law is passed before independence also, because as I said in the previous classes, there are many provisions which were borrowed from Government of India Act 1935. Government of India Act 1935, if you have watched our salient features of constitution, many laws have been borrowed from Government of India Act 1935 in today's era. So some of the laws are made by British. Even if those laws are inconsistent with the fundamental rights, that can be repealed. So after learning this, what is the right answer? Diana ma'am C, Jyoti ma'am C. Diana ma'am and Jyoti ma'am, you both are telling C. You both are right and wrong both. Whatever you are told, option C is right and also wrong. Okay, the answer is all of the above. Which among the following statements is regarding Article 13 is correct means all statements under Article 13, whatever here statements are there, are correct. Not only C, Diana ma'am, Jyoti ma'am, Lakshmi Arunodaya, yeah, D. What does first statement tells? It declares that all laws in force in India immediately before the commencement of the constitution are void if they are inconsistent with the fundamental rights. See, whenever the statement tells you if any law which is violating the fundamental right, that has to be wrong. So first statement is correct. I told you even before independence, if there is any law made by the British that is violating the fundamental rights of Indian citizen, that is wrong. So even Article 13 gives power to change that law also. First statement is correct. B option, it mandates that the state shall not make any law which takes away or abridges the rights of confirmed by Part 3. That is only no Article 13. The purpose of Article 13 na uddesha ಏನು ಭಾರತ ಸಂವಿಧಾನದಲ್ಲಿ ಇರೋದು ಏನು ಸರ್ಕಾರ ಏನಿದೆ ಯಾವುದೇ ಕಾಯ್ದೆಗಳು ಭಾರತ ಪ್ರಜೆಗಳನ್ನ ಮೂಲಭೂತ ಹಕ್ಕುಗಳನ್ನು ಕಸಿದುಕೊಳ್ಳೋ ಹಾಗೆ ಯಾವುದೇ ಕಾಯ್ದೆಗಳನ್ನ ಮಾಡಬಾರ್ದು. ಅದಕ್ಕೆ ತಾನೇ ಇರೋದು. ಅದೇ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹೇಳ್ತಿರೋದು. ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಕರೆಕ್ಟ್. Then it defines law. Article 13, it defines law to include any ordinance, order, bylaw, rule, regulation, notification, custom or usage having the territory of India force of law. I just told you. Article 13, under definition of law, even the bylaws, orders, rules, regulations, customary law, even they are included. So, all of the above option is correct. For the first time, people who are learning for the first time or attending polity classes, studying polity, it will be little bit confusing or complicated. You have to go back again and again and again, revise it, because these are important topics for any competitive exams. Now, Article 12 done, Article 13 done. Now we are starting with Article 14. Last article for the day, Article 14. What is Article 14? Article 14 is equality before the law and equal protection of the law. There are two concepts here. Equality before the law is one concept. Equal protection of law or before the law is another concept. Please keep in mind. There are two concepts under Article 14. Equality before the law and equal protection of the law. So, Article 14 of the Indian Constitution, what does it tell? ಭಾರತ ಸಂವಿಧಾನದಲ್ಲಿರೋ 14ನೇ ಆರ್ಟಿಕಲ್ ಏನು ಹೇಳುತ್ತೆ ಅಂದರೆ, ದ ಸ್ಟೇಟ್ ಶಲ್ ನಾಟ್ ಡಿನೈ ಎನಿ ಪರ್ಸನ್ ಈಕ್ವಾಲಿಟಿ ಬಿಫೋರ್ ದ ಲಾ ಆರ್ ದ ಈಕ್ವಲ್ ಪ್ರೊಟೆಕ್ಷನ್ ಬಿಫೋರ್ ದ ಲಾ ವಿತಿನ್ ದ ಟೆರಿಟರಿ ಆಫ್ ಇಂಡಿಯಾ. ಯು ಹ್ಯಾವ್ ಟು ಕೀಪ್ ಇಟ್ ಇನ್ ಮೈಂಡ್. ವಿತಿನ್ ದ ಟೆರಿಟರಿ ಆಫ್ ಇಂಡಿಯಾ, the state shall not deny equality of the law or equal protection of the law to its citizen within the territory of India. Meaning, outside the territory of India, state can deny it. Please note down. ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಏನು ಹೇಳ್ತಿದೆ ಅಂದರೆ, ಭಾರತದ ಸಂವಿಧಾನ ಏನಿದೆ, ಭಾರತ ದೇಶದ ಒಳಗಡೆ ತನ್ನ ಪ್ರಜೆಗಳಿಗೆ ಈಕ್ವಲ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಫ್ ಲಾ ಮತ್ತು ಈಕ್ವಾಲಿಟಿ ಆಫ್ ಲಾ ಕೊಡುತ್ತೆ. ಹೊರಗಡೆ ಭಾರತ ದೇಶ ಬಿಟ್ಟು ಹೊರಗಡೆ ನೀವೆಲ್ಲೇ ಇದ್ದು ಏನೇ ಆದರೂ ನಿಮಗೆ ಅಲ್ಲಿ ಅಪ್ಲೈ ಆಗಲ್ಲ ನಿಮಗೆ. ಓನ್ಲಿ ಇಟ್ ಈಸ್ ವಿತಿನ್ ದ ಟೆರಿಟರಿ ಆಫ್ ಇಂಡಿಯಾ. ಪ್ಲೀಸ್ ನೋಟ್ ಇಟ್ ಆನ್. ನೀವು ಅಮೇರಿಕದಲ್ಲಿರೋ ಭಾರತ ಎಂಬಸಿಗೆ ಹೋಗ್ಬಿಟ್ಟು ನನಗೆ ನ್ಯಾಯ ಕೊಡಿಸಿ, ನನಗೆ ಅನ್ಯಾಯ ಆಗಿದೆ, ನಾನು ನಿಮ್ಮ ಭಾರತ ದೇಶದ ಪ್ರಜೆ ಅಂತ ಅಂದರೆ ನೀವು ಭಾರತ ದೇಶದ ಹೊರಗಡೆ ಇದ್ದೀರಾ, ಅದ್ರ ಟೆರಿಟರಿ ಒಳಗಡೆ ಇಲ್ಲ. ಅಲ್ಲಿ ನಿಮಗೆ ನಾನು ಆರ್ಟಿಕಲ್ 14 ಓದಿದ್ದೀನಿ, ಪಾಲಿಟಿ ಕ್ಲಾಸ್, ಬಾಂಧವ್ ಸರ್ ಕ್ಲಾಸ್ ಅಟೆಂಡ್ ಮಾಡಿದ್ದೀನಿ, ಅಲ್ಲಿ ಕಲ್ತಿದ್ದೀನಿ ನಾನು ಅಂತಂದರೆ ಅಲ್ಲಿ ಬರಲ್ಲ ನಿಮಗೆ. ಬಿಕಾಸ್ ಆರ್ಟಿಕಲ್ 14 tells only within the territory of India. Very easy trick in examination to fool you. Examiner will fool you just by deleting the territory of India. So you will think anywhere Indian government, Indian constitution anywhere gives its citizen equality of law and equal protection of law. No. Bharata Samvidhana, Indian constitution will give its citizen equality of law and equal protection of law only within the territory of India, not outside the territory of India. That is very important. Now we'll learn what is equality of law. First concept, equality of law is borrowed from British Constitution. It's a negative concept. Equality of law is borrowed from British Constitution, that is negative concept. What does equality of law, equality before the law tells is, all individuals should be subjugated equally to the law of the land. There should not be any specific privileges in favor of any person. The Supreme Court declared this as a basic feature of the Indian Constitution. See, I will explain to you clear difference between the equality before the law and equal protection of the law. What is difference between equality of the law and equal protection of the law? First difference I already told you. Equality before the law is taken from British Constitution. It is a negative concept, but equal protection of law is a positive concept which is taken from USA. Equality of the law, British concept, negative. Equal protection of law, positive concept, USA. Now, what is different between equality before the law and equal protection of law means, in equality before the law, you give equal treatment to everyone. Example, Bhandav is here. Along with Bhandav, there are other two members. Say Bhandav, Mr. X, Mr. Y. Now, how do you equally treat them? Under equality before the law. Under equality before the law, under this concept, equality before the law, how you treat all three of them is, all three are hungry now. ನಮ್ಮ ಮೂರು ಜನಕ್ಕೂ ಹೊಟ್ಟೆ ಹಸಿತಿದೆ. ನಮ್ಮ ಮೂರು ಜನ ಈಕ್ವಲ್ ಆಗಿ ಹೆಂಗೆ ಟ್ರೀಟ್ ಮಾಡ್ತಾರೆ ಅಂದರೆ, ಮೂರು ಜನಕ್ಕೂ ಒಂದೊಂದು kg ಬಿರಿಯಾನಿ ಕೊಡ್ತೀನಿ. You are giving 1 kg biryani to all three of us. That is, you are equally treating all of us by giving 1 kg of biryani. But what is the problem with this concept? Why this concept is negative? Why treating all three of us equal is a negative concept? Means because Bhandav, my capacity is 2 kg biryani. How example I am giving you? My capacity is 2 kg biryani to satisfy my hunger. ನನ್ನ ಹೊಟ್ಟೆ ಹಸಿವನ್ನು ನಾನು ನೀಗಿಸ್ಕೊಳ್ಳಲು ನಂಗೆ 2 kg ಬಿರಿಯಾನಿ ಬೇಕು, ಬಟ್ 1 kg ಕೊಡ್ತಿದ್ದೀರಾ. ಬಿಕಾಸ್ ಯು ಆರ್ ಟೆಲ್ಲಿಂಗ್ for all three of you I am giving only 1 kg biryani. I am equally treating you. But Mr. X capacity is only 500 grams biryani. What you will do with excess 500 grams? That is wastage, no? Yes, forcefully he is eating. Mr. Y capacity is 3 kg biryani, but you are giving him only 1 kg biryani. Bhandav capacity is 2 kg, but you are giving only 1 kg biryani. Yes, you are treating us equally for all three of us. For Bhandav, Mr. X, Mr. Y, for all three of us you are giving 1 kg biryani. You are treating us equally, but that is not satisfying our needs. That is wastage. But this concept, equal protection of law is a positive concept. Under equal protection of law, you know what you will do? Bhandav, you are hungry. What is your capacity, Bhandav? How much you need to satisfy your hunger? I will say 2 kg biryani. Then you will give me 2 kg biryani. Mr. X capacity is only 500 grams. So you will ask Mr. X, how much you want to satisfy your hunger? Only 500 grams. So you are giving only 500 grams. Mr. Y, 3 kg capacity. So you are giving him 3 kg biryani to satisfy hunger. Ultimate goal is to satisfy our hunger. Ultimate goal is not you are giving us equal biryani. Equal ಆಗಿ 1 kg biryani ಕೊಟ್ಬಿಟ್ಟು now all of you are good. No sir, we are not good because our capacity is different. No, not all human beings are same in this world. Under equal protection of law, under positive concept, ultimate goal is to satisfy our hunger. No matter how much biryani we eat, you care about ultimately at the end is our hunger satisfied. That is why it is positive concept. Artha agtidya? I have explained you in the most simplest procedure, in simplest form. Diana ma'am, procedure established by law Japan. Yes, both USA and Japan ma'am. Though we borrowed it from Japan, from where did Japan borrow it? Basically, it is from USA only, because Japan is like US's pet after Hiroshima Nagasaki bombing basically. So USA and Japan both procedure established by law, equal protection of law. So ಇದನ್ನು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ, ಸಿಂಪಲ್ ಆಗಿ ಹೇಳಿದೆ, ಅರ್ಥ ಆಯ್ತಾ? Equality before the law, negative concept, that is borrowed from British. That is, you are equally giving 1 kg of biryani to all three of us, but which is not sufficient or which is not reaching the end goal. Under equal protection of law, you are not equally treating us, but ultimate goal is you are satisfying all our hunger. Then that is positive concept, that is equal protection of law. So Article 14 applies to both citizens and foreigners, not only to citizens of India. Whoever foreigner visiting India as a tourist or whatever work is, even for foreigner also Article 14 is applicable, not only to citizen. The term person in the articles refers to not only individuals but also companies, not only living beings. Also the company, if you are opening any company, for that company also there is equal protection of law. The Indian court cannot treat Bandhav's company and Anil Ambani's company partiality. Oh, Anil Ambani, nam sambandhikru ivrige ಒಳ್ಳೆ ನ್ಯಾಯ ಕೊಡೋಣ, Bandhav company no. If Bandhav's company and Anil Ambani's company, if they fight each other in the court, for them also court should treat them equally, should apply equal protection of law and equality before the law. Even for non-living beings companies also that is applicable, Article 14, not only for living beings. So today that is what we learnt about Article 12, Article 13, Article 14. Article 12 definition of state, Article 13 laws that are inconsistent with the fundamental rights, Article 14 equality before the law and equal protection of the law. The negative concept versus positive concept, the British borrowed from British versus borrowed from USA, Japan. So I hope you understood today's topic. Please go back and watch our classes again. And don't forget that link which is in the description, because this upcoming webinar is very important to you. The upcoming webinar which will be giving you clear idea about which this webinar, upcoming webinar on Saturday, on 14th of June 2025 by our dedicated mentor Ashwini ma'am through Zoom call at 7 p.m. This is very important for you. If you want to attend this webinar, you have to register before, so that link will be given to you to access the webinar, or else how can you access the webinar which is happening online? So please go tell your friends, forward it to your friends also, to all those aspirants who wants to appear for government competitive exams. Tell them to attend this webinar. After this webinar, they are getting good insights. Which post is important to them? What is their clear vision? Which exam they need to follow? And obviously this is free, students, like how our online classes are happening. This is free, not paid in any terms. So this is from Veranda Institute to support students, those who are preparing for competitive exams. So there is no money involved here. This is free webinar dedicated by our Ashwini ma'am, especially KPSC, SSC, banking and railways. Do attend this webinar and get good insights. Jyoti ma'am, thank you ma'am. I will keep continuing. You also keep attending my classes. Diana ma'am, every day keep attending my online classes. I will explain you concepts in simple manner as possible. Arunodaya, Lakshmi Arunodaya, thank you ma'am. Yes sir, thank you sir. Ayu, thank you sir. Thank you.